Okay, so let's begin. We're recording. I'd like to thank you for joining me on today's discussion. Today we're in session number 4 of our ongoing series entitled the Fall Zoominar series. And today I want to talk to you about how to eliminate bias in the face-to-face and in the medical legal evaluation. And before we get started, just a couple of technical and administrative issues here. We have doctors and attorneys attending today's Zoominar, so I have something for both groups. If you open your chat, which is down at the bottom of your Zoom screen, in the center of the screen is the chat button. If you open your chat button, you will see that there's links for both QMEs and attorneys. What these links contain is they contain all of your course materials, all of the reports and studies and cases that support the discussion. So go ahead and click that link right now and verify and confirm that it works. What that'll do is it'll take you to a page on my website. And the page on the website will look a lot like this. So you're seeing this on my screen, correct? How to eliminate bias in blue. So this is my website. Here it shows the link to the exam. This is an online exam that'll allow you to take your 3-question exam and to get your certificate of completion immediately. Here are all the downloadable materials that support today's discussion. And if you see this one here on the bottom, the course materials combating bias in the QME evaluation, QME edition. This is a Microsoft Word document that will also contain all of these links and allow you to access all of these materials. So what I suggest is that you download that and save that. That will allow you to come back to the materials over and over again at your own leisure. So you have a couple options. You can either download the materials now as we go through the discussion. I will leave the discussion open for 5 minutes after we conclude. That'll give you opportunity to download the materials, or you can download this final document here, save it, in which case you can access your course materials forever. Okay, any question on that, anybody?
Yes. No question.
Okay. So each one of these is a downloadable file that'll support today's discussion. Okay. Okay, so let's get into today's discussion. So what I want to talk to you about today is a very important, hot and timely topic regarding bias in the medical legal evaluation. Early in 2021, commenced what I consider to be the anti-bias movement. That movement is now gaining momentum here as we approach 2022. And in fact, new legislation is going to come to pass and is going to be imposed upon us as qualified medical evaluators to twist our elbows and to get us to the point that we take some time to consider our opinions and conclusions in our reports before we offer those opinions and conclusions, to confirm to ourselves first, and then to confirm to all the parties secondly, that indeed all of our opinions and conclusions are accurate and are not in any way shaped, colored, influenced, formed, formulated, or impacted by a lifetime of preconceived notions that we harbor deep inside all of us in the form of stereotypes, biases, and other forms of discrimination. So the system is moving toward what they consider to be accurate opinions and conclusions. And one of the facts and factors that colors opinions and conclusions of qualified medical evaluators that make those conclusions not accurate are biases. So we're entering what I refer to as the anti-bias era. And I want to share some ideas with you as to how you can start to opine more accurately in your cases. Okay, so with that as our introduction, many of you know me. I'm a continuing education provider for the Division of Workers' Compensation for about 10 years now. I'm also a continuing education provider for the State Bar Board of Legal Specialization. So we have attorneys with us on today's Zoominar. Both of you are going to get continuing education credits. And I share some of these background histories about me to let you know that I have access to a large volume of cases, and that access to a large volume of cases is what allows me to spot trends in the industry. And I'm sharing with you some of the trends that are developing now as relates to bias in the medical legal evaluation. So just to put this into context, I said that the anti-bias movement began in approximately early 2021. And some of the things that have shaped the anti-bias movement have to do, number one, with the new medical legal fee schedule. New medical legal fee schedule, as you know, was implemented on April 1st, 2021. And the new medical legal fee schedule introduced a whole new economy to the qualified medical evaluation, not only as relates to QMEs, but it introduced a whole new economy as relates to the claims administrators, whole new economy as relates to the applicant attorneys and the defense attorneys, and the ways that each of those parties made money in the system prior to the adoption of the new medical legal fee schedule has changed. And therefore, all of the parties, not just the qualified medical evaluators, have changed all of their operating procedures under the new game. It would be just like if you were a basketball player and played your whole life according to a certain set of rules, and then all of a sudden the rules changed. Everything you knew about dribbling, shooting, and making plays and scoring points had to be reformulated. And so that took place in April 2021. And then shortly thereafter that, right on the heels of that, the Division of Workers' Compensation started ramping up under pressure from the state auditor to improve the content and quality of QME reports. And all the parties in the system, aside from QMEs, aside from the QMEs, conclude that QME reports range generally from terrible to worse. Surprise, surprise. And so under pressure, the Division of Workers' Compensation is now taking measures to address QME reporting. And part of the addressment of QME reporting has to do with the proposal of new regulations to address bias in QME reporting. So part of the problem of terrible QME reports has to do with the fact that QMEs have all these biases that shape their opinions and conclusions that result in reports that are just not accurate. So that's contributing to where this movement is going. In June, we saw the momentary passage. I say momentary because it was very quickly vetoed. But we saw the momentary passage of Senate Bill 788. Senate Bill 788 was a revolutionary new law that passed through the Senate and found its way onto the governor's desk. And the governor, for whatever reason, just vetoed it about 3 weeks ago. But it was an attempt, it was a legal attempt to eliminate bias from the apportionment arguments that we offer as qualified medical evaluators. And even though Senate Bill 788 was momentarily vetoed, the spirit behind the language of that law persists and is being perpetuated in the new QME regulations, which are expected to be passed 1/1/2022. On an ongoing basis, even as we speak, the Division of Workers' Compensation is holding ongoing report quality committee meetings. I'm on the report quality committee. In fact, we have a meeting this Friday. And the report quality committee is a group of stakeholders, which includes QMEs, applicant attorneys, defense attorneys, all these stakeholders in the system. who by hook or by crook are going to try and wrestle better quality reports from us as qualified medical evaluators, including getting us to eliminate bias from our opinions and conclusions. And you're going to be hearing a lot about this in the weeks and months to come, because your reports, our reports, all of our reports are going to be coming under closer scrutiny by the attorneys, by the judges, and ultimately by the Division of Workers' Compensation. And the Division of Workers' Compensation is just going to be eliminating from the system qualified medical evaluators who fail to show improvement or fail to show progression in their skills in being able to write reports that can actually resolve disputed issues. Okay, so you'll be hearing a lot more about that. As the defense attorneys and the applicant attorneys learn about how the Division of Workers' Compensation is going to be leaning on qualified medical evaluators, those players, the applicant and the defense attorneys, are becoming smarter in how they communicate with qualified medical evaluators through the cover letters. And you're going to be seeing cover letters that require more analysis from you, more consideration of different issues from you, more in-depth introspection into your opinions and conclusions. And you're going to be required to be more familiar with recent case laws. So for example, just as an example, in 2021, we had these several cases, the Lynn case and the Wiest case, which impact new thinking related to permanent impairment, new thinking related to combining impairments, new thinking with regards to the apportionment of permanent impairments. And it's going to be incumbent upon each of us to stay current with case law. It's going to be demanded through the attorney cover letters that we do. So we're addressing that here at Easy Continuing Education every Tuesday. We're putting out a new blog. It's entitled Case Law Update. You get that every Tuesday. Every Tuesday, we have an expert who reviews an important case, a relevant case, and provides analysis of those cases and how those cases apply to you and your evaluation. So look for that every Tuesday. Just last week, another thing that happened is the emergency regulations, which gave us more breathing room on all of our timelines. The emergency regulations were set to expire on October 15th. Well, the Division of Workers' Compensation was in a bit of a quandary as to how to handle that or what to do next regarding all of these COVID provisions that we've been allowed. Well, they handled that by giving us an extension through January, I think it's January 10th. I might have here January 15th, but I think it's January 10th actually. So they gave us a 90-day extension on the opportunity to participate in telehealth, the opportunity to do electronic submission of our reports. And so that's good news. And probably what's going to happen is the COVID extension through January 15th is probably going to coincide with the passage of the new QME regulations on or about 1/1/2022. So the Division of Workers' Compensation is kind of off the hook as to how to handle the COVID emergency regulations, because those are just going to blend in and probably will be perpetuated forever as they become adopted into the new QME regulations, okay? So that brings us about current and into the anti-bias era. And if the new QME regulations pass on 1/1/2022, there will be language in those regulations to combat bias in the medical legal evaluation. And that's what I want to share with you here in today's discussion. Now, it's interesting because here we are in 2021 and the Division of Workers' Compensation is for the first time, at least formally, addressing bias in the system. Well, efforts to combat bias in society around us have been ongoing for decades, but it's only now come to the top of the DWC's priority list. Well, as an example, I saw this just the other day at a Dick's Sporting Goods store. They had this poster outside the men's and ladies' room at the Dick's Sporting Goods store. And Dick's Sporting Goods says that they have a zero tolerance for bias and discrimination. And it's amazing that only now is it being addressed by the Division of Workers' Compensation. But in my opinion, it's better later than never, okay? So we're now at the point where the DWC is addressing it. And so let me share with you what the purpose and what the division's plan is. So the purpose of our discussion today is to explain to you what is the DWC's plan to combat bias, first in the face-to-face evaluation, and then also in the reporting by us as qualified medical evaluators. And then if you can understand that, if you can understand their plan and their intent, then you'll understand how you can arrive at opinions and conclusions and write your reports such that they're free from bias, so that appropriate and accurate benefits can be provided for all persons. Because the unintended effect of bias in the face-to-face evaluation and bias in the medical legal evaluation at large is to provide inaccurate benefits, is to provide benefits that are not an accurate reflection of the examinee's true needs. And the parties and the system seeks accuracy. Nobody in the system has any problem accepting your opinions and conclusions, whatever those opinions and conclusions may be, as long as those opinions and conclusions are accurate. Okay, so even if your opinions and conclusions cost the insurance company a ton of money, as long as it's accurate, meaning can be supported by substantial medical evidence, meaning it's accurate, nobody has a problem with that. On the other hand, if your opinions and conclusions at the other end of the spectrum completely deny the injured worker benefits for a $0 claim, nobody has any problem with that as long as it's accurate. So the system and the purpose of the anti-bias movement is to push qualified medical evaluation reports towards accuracy. Okay, so let's talk about it a little bit. So let's define bias. What is bias? I have here a definition of bias for us from Wikipedia. Wikipedia tells us that bias is a prejudice either in favor of or against one thing, like what? Like what one thing? Like how about overweight? How about underweight? How about elderly? Okay, one thing, one characteristic. Favor of or against one person, like what? Like how about an examinee? Like how about the applicant attorney? How about a group? How about a group of people like qualified medical evaluators in general or claims administrators in general? Many qualified medical evaluators have biases against claims administrators in general as a whole group, thousands of claims administrators. Okay, so it can be against a thing, a person, or a group. And we refer to these as the targets of bias. So it's usually in a way that's considered to be unfair. Biases can be held by an individual, by a group, or an institution, and they generally have negative consequences. And in the workers' compensation system, the negative consequence is that those prejudices result in benefits that are not accurate. Now, when we talk about targets of bias, we're going to, in this discussion, focus on person targets of bias in the system and also characteristic targets of bias. So who are the parties, who are the players in our small system, in our world, for whom we can hold unfair prejudices? Well, certainly, the focus of all prejudice is on the examinee, but also there's the claims administrator, there's the applicant attorney, there's the defense attorney. I say here that there's others also, because I was recently at a seminar where there was a workers' compensation judge speaking, and the workers' compensation judge himself admitted that he had biases, and he used the word, "This is just my bias," he said. He had biases against a couple of different specialties of qualified medical evaluators, and he exposed his biases for the whole audience to witness. And so each of the persons involved in your case in chief, each of the persons have biases and prejudices toward each of the other persons involved in your case. And I'll share with you some examples, but you just have to know this. You just have to understand this going into the evaluation. Now, each of these persons themselves have individual characteristics that can be targets of bias as well. Now, the Division of Workers' Compensation has elaborated or has identified these as their specific targets that they want to combat, such as race being a target of bias, such as they refer to sex as a target of bias, that what they really mean is gender. National origin is a target of bias. And don't we see many, many examinees who come from a different nation than from where we come from, okay? So the system wants us to provide those injured workers that come from a different nation a fair look, a fair shake. They want us to provide opinions and conclusions that are accurate, regardless of where the injured worker comes from. Religion, sexual preference, but other targets of bias include also age. In other words, have you ever found yourself sitting face to face with an examinee who's perhaps 69 years old, and this person is telling you about the industrial injury that they suffered, and you find yourself thinking, well, of course you suffered an industrial injury, 69 years old. 69-year-olds suffer musculoskeletal injuries, and we have these notions. Not all 69-year-olds suffer injuries. Not all 69-year-olds have the same lifting capacity. Many 69-year-olds can outwork some 25-year-olds. But age is one of those targets that we just have in us. You just have to know it, that the Division of Workers' Compensation wants us to eliminate. Gender identity, marital status, if you can believe that, disability, physical abilities. We have these ingrained notions and preconceived notions about people with disabilities compared to able-bodied people. You just have to know it. So if you consider all of these characteristics and look at your examinee, we have an examinee who may be a different age than us, may have a different race than us, may have a different gender identity, and have all these physical characteristics that serve as sources of prejudice for us as qualified medical evaluators. What about the claims administrator? Well, there's not a lot that we can learn about the claims administrator because we don't have a face-to-face interaction with the claims administrator. But if you've spoken with the claims administrator on the phone, or you've spoken to your staff who's spoken to the claims administrator, you know you can probably determine roughly the age of the claims administrator. You can determine the gender of the claims administrator. You can certainly determine the cooperativeness of the claims administrator. And for those claims administrator who are not cooperative, don't you have some feelings about those types of claims administrators? When you get the cover letter from the claims administrator, do you develop an image or a perception of the claims administrator? I can tell you I do. I have a cover letter here. I have a cover letter here from a claims administrator. Now, but he needs to mute. I have a cover letter here from the claims administrator, and it's a completely boilerplated cover letter. And it says regarding causation, it says in this cover letter, it says there exists a bona fide dispute with industrial causation in this case. And then in parentheses, it says, fill in details in great detail. It says, fill in details in great detail. So this is a templated cover letter that the claims administrator is supposed to customize, but it failed to customize the cover letter and sent it uncustomized. So do you develop a perception about the claims administrator through their cover letters? Yes, we do. I have a perception about this claims administrator. and it's not that positive, okay? Well, what about the attorneys? Can we as qualified medical evaluators have biases toward particular applicant attorneys or particular defense attorneys? And in the other end of the spectrum, can they have biases against us as qualified medical evaluators? They do, don't they? They have biases. That's what causes them to leave you the last man or woman standing, or that's what causes them to strike you from the panel, is because of their biases, either in favor of or against you as the qualified medical evaluator. And then of course, the qualified medical evaluator, all of the parties look at the qualified medical evaluator through their lenses of bias. And that's why qualified medical evaluators sometimes are negated simply based on their specialty. That's why they're sometimes chosen just based on their specialty. And so we have all of these interlacing and interwoven web of biases that unfortunately impacts the injured worker in the provision of benefits that are not accurate. And what we're after is we're after accuracy. So I've included for you in your handout materials some examples of bias in the workers' compensation system. I've included for you the Page versus Perry Soto lawsuit, which involves gender bias. I've included an example of national origin bias. I've included an example of racial bias, and you should read each one of these cases because each one of them is going to blow your mind. Each one of these blew my mind when I first read them, because you're going to find and you're going to conclude that these biases are sometimes very, very subtle. Okay, they can be, on the one hand, they can be very overt, but on the other hand, they can be very, very subtle. And you're going to find yourself reading these studies and realizing that you yourself, whether you've confronted it or not, you yourself have many different person and characteristic targets of bias yourself, and it could be no other way. Could be no other way. But simply being able to identify that in yourself is going to help make you a better QME report writer. Okay? So let's talk about the Page versus Perry Soto lawsuit. This is one of the references that I provided for you. This is what really started the whole anti-bias movement, is the Page versus Perry Soto lawsuit. Now, this lawsuit was filed in 2016 by a group of women who were accusing the Division of Workers' Compensation of gender bias in the provision of benefits to injured workers. And they alleged that the workers' compensation system unlawfully discriminates on the basis of sex. And what they mean by sex is they mean gender, in the calculation of permanent disability benefits, benefits which are intended to compensate injured workers for long-term physical loss and the loss of earning capacity. So they're talking about inaccurate benefits, and they cite two main ways that the system discriminates against women. They said, number one, women receive fewer permanent disability benefits than the extent of their injuries merit because the harm that's unique to women is ignored. Harm unique to women, mostly by male evaluators, correct? Most qualified medical evaluators, in fact, in some specialties, 97% of evaluators are male evaluators. So male evaluators have bias about the female gender and therefore provide for inaccurate permanent disability benefits. So this has to do directly with our permanent impairment ratings for women. Okay, so that's the number one source of inaccurate benefits, is lowered, too low impairment ratings based upon gender bias. The second is that those reduced benefits, to begin with, those reduced benefits are further reduced for no reason other than the worker's gender. These permanent disability benefits are routinely reduced because women's injuries are apportioned. In other words, the percentage of the permanent impairment due to the industrial injury is reduced on the basis of bias or risk factors or predisposing conditions of the female gender and or of women's reproductive biology. So to add salt to the wounds, women argued in the Page versus Perry Soto lawsuit that, first of all, their permanent impairment ratings were too low because the permanent impairment rating provided by male evaluators didn't accurately reflect their actual impairment, number one. And then number two, those lowered permanent impairment ratings, which translated into permanent disability ratings, were further apportioned based on biases related to the female gender. So specifically in the Page versus Perry Soto lawsuit, this involved 3 individual female claimants and then thousands of collective women who made these allegations. Claimant number 1 was a case that involved a carpal tunnel syndrome impairment rating, where the male qualified medical evaluator apportioned 20% of the low permanent impairment rating anyway that's provided for by carpal tunnel syndrome, apportioned 1/5 of that to non-industrial risk factors because the carpal tunnel syndrome injured worker was a woman. And the qualified medical evaluator opined that, well, women commonly get carpal tunnel syndrome, especially postmenopausal women. And this woman was a postmenopausal woman. And he concluded that because she was a postmenopausal woman, she had a predisposition or a predisposing condition that was causing some of the permanent impairment at the permanent and stationary date. And claimant number 1 rebelled because she was being punished, meaning her benefits were being reduced simply on the basis that she was of the female gender, a condition over which she had no control. Claimants number 2 and 3, these had to deal with industrial breast cancer. One woman had a single mastectomy. The other woman had a double mastectomy. In other words, removal of a single breast, removal of a double breast. And the AMA guides provide for very low impairment rating for single or double mastectomy. They provide for a 0% whole person impairment rating in a postmenopausal female or in any female not involved in nursing a child. So unless you're nursing a child, the loss of the breast, according to the male authors of the AMA guides, provides for a 0% impairment rating. And these claimants argued that that 0% impairment rating did not sufficiently describe the losses that they suffered. And they alleged that their permanent impairment benefits, permanent impairment rating was not accurate on the basis of gender discrimination. Finally, the California State Council, which represents thousands of injured female workers, they alleged that their members are subject to illegal reduction in their workers' compensation benefits on account of their gender. This group was referred to as the apportionment group. And it goes back to what we were saying before, that women were alleging that their permanent impairment ratings were being apportioned to their reproductive biology or to the predisposing condition of simply being of the female gender. So this case was filed in 2016. It floundered for a while. In 2017, it was found to have been filed in the wrong court. In other words, it was filed in Los Angeles Superior Court, and they ruled that this was a matter that could only be handled by the Workers' Compensation Appeals Board, the WCAB. And so this lawsuit floundered and really lost momentum, but the point of it was well noted. And now in 2020, this has come to the top of the DWC's priority list, and the DWC has now written new legislation or new proposed legislation to address these very issues. So let me share with you what is the division's plan. So here's the Division of Workers' Compensation's plan to combat bias in the medical legal evaluation. And you'll notice that this plan spans the entire life cycle of the qualified medical evaluator, beginning back here before a prospective QME even sits for the competency exam. So in order to be eligible to sit for the competency exam, new CCR 11 is going to require that new doctors take training in anti-bias training. They call it anti-bias training to help them become sensitive to these bias issues. So even before the doctor sits for the competency exam, he has to demonstrate compliance with CCR 11. Then along the life cycle of the QME, the Division of Workers' Compensation is going to be placing new emphasis on the disclosure requirements under CCR 40. Now, I'd love to spend about an hour talking about the disclosure requirements because it's very, very important. I'll just say this about it today, and that is, I said that I'm on the Report Quality Committee, and we're having a meeting on Friday. Well, in order to be prepared for that meeting on Friday, each member of the committee has had to review 10 reports, all the same reports. Each committee member has reviewed the same 10 reports. And we're going to get together on Friday and we're going to discuss our findings on these reports, and we're going to determine what's good about each report and what's bad about each report. And I'll just tell you now that I've already done my reports and I've submitted them to the Division of Workers' Compensation. And 1 out of the 10% complied with the disclosure requirements. 9 out of 10 had no evidence that they'd gone through the disclosure requirements with their examinee, and it's required. It's on the check sheet. The Division of Workers' Compensation is going to be clamping down to find out whether or not you're doing the disclosure requirements. So if you need information on that, get a hold of me and I'll tell you how to go through the disclosure requirements with your examinee. You want to do it. It's a fabulous procedure. It only serves you and the examinee. So in addition to that, along the life cycle of the QME, new proposed CCR 35.5, this is new, probably going to pass January 1st. At the end of every report, you're going to be required to sign a mandatory declaration. The declaration confirms to the parties, by your signature that is, confirms to the parties that no part of your report is in any way influenced by bias, that there's no bias against any of the persons involved in the case, and there's no bias against the examinee, certainly on the basis of all of those targets, race, gender, sexual orientation, all those things. And that language is written in to this declaration. So the purpose of this declaration is to cause you to stop and think before you put your report in an envelope, and to confirm first to yourself and then to the parties by your signature that your report is indeed free from bias. Then on an ongoing basis, we're going to be required to complete 2 hours of anti-bias training every 2 years as a condition of reappointment as a QME. And then new CCR 51 section 10 has a provision that disallows the reappointment of the qualified medical evaluator if it can be found that the qualified medical evaluator is consistently, as a pattern in practice, submitting reports that are influenced by bias. Now, this is going to be difficult to prove because most bias is subtle, but if it can be shown that your reports are influenced by bias, you will be denied reappointment by the Division of Workers' Compensation. So this plan spans the entire life cycle of the qualified medical evaluator. It's a very comprehensive plan, and in my opinion, they've really hit all the high notes, especially requiring two hours of continuing education every 2 years. So that's going to help keep this concept of bias right at the front of our consciousness. Okay, so let me share with you some ideas as to where and how bias can manifest in the face-to-face evaluation, and then also in your medical reporting. So let's introduce a new topic and continue with our definition of bias, again from Wikipedia. So they tell us that bias is the pre-reflective attribution. And if you're a psychologist listening to this, you know a lot more about this than I, and you could probably lecture on this for an hour. But a pre-reflective attribution is before thinking. It's reflexive. It's pre-reflective. We have these inside of us. It's the pre-reflective attribution of particular qualities by an individual, such as a qualified medical evaluator, to a member of some social in-group or some social out-group. Now, there's this concept of what are called social in-groups and social out-groups. Social in-groups include people that are like us, that are like you. So when a person is the same gender as you, they fall in your gender in-group. When the person is from the same nation of origin as you, they fall within your same national origin in-group. When people are like you, they fall into your general box of categorization, referred to as your in-group. Now, on the other hand, people that are dissimilar from us, dissimilar from you, are placed in the box referred to as your social out-group. And your out-grouping can be based on any number of the characteristics or any multiple of the characteristics that we've already talked about. People who have a different decade of birth could fall in your social out-group. People who have different physical body type than you fall in your social out-group, okay? So there's this concept of social in-grouping and social out-grouping. Well, bias then is a prejudice in favor of or against one thing, one person, one group, the out-group. It's against, bias is a prejudice against the out-group compared with the in-group for whom you favor. So we have this concept of in-group favoritism and out-group negativity. Let's expand on that. So with the in-groups, people who fall within our social in-groups, we tend to favor them, right? We tend to consider them to be similar to ourselves, and unconsciously through bias, we tend to provide favoritism in our opinions and conclusions towards those people. On the other hand, people who fall in our social out-group, we tend to burden or punish in the form of negativity. So social psychologists have long made the distinction between in-group favoritism and out-group negativity, where out-group negativity is the act of punishing or placing burdens on the out-group. So imagine your examinee. If your examinee is different from you, looks different from you, from a different country than you, speaks a different language than you, has a different body type than you, this is an examinee who, through bias, through unconscious bias, is going to be pigeonholed into your social out-group. This examinee is then going to be subject to your opinions and conclusions, generally toward the spectrum of punishing or placing burden on that examinee. And I'll share with you some examples of how this manifests in the work that we do. Indeed, a significant body of research exists that attempts to identify the relationship between in-group favoritism and out-group negativity, as well as the conditions that will lead to out-group negativity. And I'll share with you some ideas as to what some of those conditions may be, at least in the realm of the medical legal report. So here I have a table, and across the top of the table, I've listed some of the parties and some of the players in your very next case. This is your very next case. There'll be an examinee, and there'll be a claims administrator, there'll be an applicant attorney, there'll be a defense attorney. And let's just imagine that you're in what we call an applicant-oriented qualified medical evaluator. If you're an applicant-oriented qualified medical evaluator, then the examinee and the applicant attorney will be in your social in-group. And the claims administrator and the defense attorney, those people who are dissimilar from you, will be in your out-group. So what is the form of favoritism that you could opine for those members in your in-group, meaning the examinee and the applicant attorney? Well, in the case of a denied claim, where you're being called to evaluate causation, you will likely opine AOE, COE through unconscious bias favoring your in-group. You will opine for total temporary disability benefits. You will opine for high permanent impairment ratings, higher than perhaps are accurate. If you provide an impairment rating, you will likely provide for a low apportionment percentage to be due to other factors and a high percentage of permanent impairment to be due to the industrial injury, thereby shifting benefits inaccurately and unfairly toward the members of your social in-group. Well, what about the punishment? What about the punishment for the out-group? The punishment for the claims administrator, punishment for the defense attorney is a finding of perhaps not permanent and stationary. Some finding that allows the examinee to continue to receive benefits when perhaps they actually don't qualify for additional benefits. You may punish the claims payer by ordering expensive and additional diagnostic studies that perhaps are not really necessary, or perhaps not going to change any of the course or the outcome of the case. You may provide for additional total temporary disability, and in this way, punish those in your out group, but show favoritism to those in the in group. And the conditions that lead to this are any number of prior history or prior experiences with perhaps examinees like this, perhaps prior history with the same applicant attorney. Perhaps you could have out-group negativity towards a claims administrator due to a prior experience with the claims administrator. I know one qualified medical evaluator, at least under the old fee schedule when we used time-based billing codes, he told me every time when he had some disagreement with the claims administrator, such as the claims administrator didn't pay him timely or the claims administrator reduced his reimbursement, he told me that he would have the last laugh. He would get the claims administrator on the very next case. He would spend extra time in the face-to-face evaluation or perhaps find an extra hour of review of records time. In other words, you understand what I'm saying? That was under the old fee schedule, but he had prior experience that shaped the way he approached his very next case with the same claims administrator. Now, on the other hand, let's take the other type of qualified medical evaluator. Here's a qualified medical evaluator considered to be more of a defense-oriented qualified medical evaluator. With a defense-oriented qualified medical evaluator, the claims administrator and the defense attorney are in the social in-group, and the examinee and the applicant attorney are in the social out-group. So the favoritism for those in the in-group, the claims payer, would be a finding against industrial injury, no AOE, COE, no injury, no benefits, no TTD. If it's an accepted claim and it does pass through the AOE, COE portal of entry, you might opine for either low or even no permanent impairment against this examinee who, in your opinion, based on your prior experience, this examinee actually doesn't have actual impairment. If there is impairment, you'll provide a high apportionment to other factors and a very low apportionment percentage to the industrial injury. You might reduce the work restrictions to the point that the injured worker has to go back to work, either in the usual and customary duties or something very close to those to force them back to work, all of which provides for favoritism to the payer of the claim, the claims administrator. On the other hand, the negativity would be directed toward the examinee and the applicant attorney, where you would deny injury. In other words, there's no benefits being delivered whatsoever. If the examinee, for example, I'm just making this up, all of this is made up. If the examinee did have an actual condition, you would opine that that condition was a non-industrial condition for which the employee could receive treatment from the primary care physician, okay, on a non-industrial basis. And all of these findings are based on prior history and prior experience. Again, with examinees like this, again, with applicant attorneys like this, okay? We have all these biases and preconceived notions. You know, I have some cases that I get from applicant attorneys where the applicant attorney has no participation in the case. There's no cover letter. There's no sign or indication that the applicant attorney has scheduled the appointment or communicated with the examinee and has no involvement in the case. And I have to be honest that that's the type of thing that can lead me to have a negative assessment of the applicant attorney. And that's something I need to consider with each case when I'm confronted with that type of an applicant attorney. So we have all of these biases based on our social in-groups and social out-groups. So I just want to share with you one more idea and then we'll open it up to discussion. And this is fascinating. And it has to do with another type of bias, another type of in-group and out-group bias based on our beliefs. So this is referred to as the belief congruence theory. And the belief congruence theory concerns itself with the degree of similarity of beliefs. People who believe like we believe, have similar beliefs to us, fall in our in-group. People who have beliefs dissimilar from ours fall in our out-group. So it's based on similarity in beliefs, attitudes, and values that we perceive to exist between us. They may not be actual, but it's how we perceive the similarity of beliefs to be. This theory states that dissimilarity of beliefs increases negative orientations towards others. When applied to, for example, racial discrimination, the belief congruence theory argues that the perceived dissimilarity of beliefs has more of an impact on racial discrimination than does race itself. So what this is stating here is that with regards to racial discrimination, when we have persons of different races, the dissimilarity, the perceived dissimilarity stems not from differences in color of skin, not from differences in texture of hair and these physical characteristics, but it has more to do with perceived dissimilarity in beliefs. And do we not have injured workers that we sit from across face to face in the evaluation who have dissimilar beliefs from that which we have? We do. Many of them have very dissimilar beliefs than what we do. And for example, what are the similar beliefs of the examinee and the applicant attorney, the in-group of the applicant-oriented qualified medical evaluator? And I've spoken to many qualified medical evaluators that'll tell me that, hey, Perry, the insurance companies, they screw everyone. They screw everyone. This is the similar beliefs of the applicant attorneys, similar beliefs of the examinees, similar beliefs of some qualified medical evaluators. Well, if this is the belief of the qualified medical evaluator, how is that going to impact qualified medical evaluators' opinions and conclusions? Some of them believe that, hey, employers, all these employers, they're all crooks and they fraudulently hide injuries and they don't report injuries. And the medical treatment, you know, the medical treatment in the workers' compensation system is terrible. It's terrible. It's substandard, and that explains why examinees never get well, even 2 years after the industrial injury. And this is just a series of beliefs shared by the members of this social in-group, which you may find yourself drawn into this social in-group if you consider yourself an applicant-oriented QME. On the other hand, the beliefs of the out-group here, the claims administrator and the defense attorney, are that all these people are fakers. They're all fakers. They're just seeking benefits. They're benefit seekers, they're scammers. And guess what? Even if we give them treatment, they're never, ever going to get well, or at least they're never, ever going to admit that they're getting well from the treatment that we're providing. On the other hand, when the examinee and the applicant attorney are in the qualified medical evaluators out group, and the claims administrator and the defense attorney are in the in-group, this is the so-called defense-oriented qualified medical evaluator, the similar beliefs shared is that, hey, all these people are exaggerators. They magnify their symptoms, they're symptom magnifiers, and not only do they have a claim for an industrial injury going on, they're poly-claim mongers, meaning they also have a claim for a subsequent injury fund claim. They also have a discrimination claim. They also have a wrongful termination claim. They have all of these claims going, and the work injury is just a tandem claim tacked onto these other claims. Whereas the examinee and the applicant attorney, they have different beliefs in that, hey, I've been injured, I need benefits. It's a very, very bad injury that nobody understands, and therefore I can't return to work. So it's these dissimilarity of beliefs between the social in-groups and the social out-groups and the orientation of the qualified medical evaluator that can cause an inaccurate conclusion from the qualified medical evaluator. So I want to open this up to some discussion. These are things for us to think about, at least at this early point in the anti-bias movement. Now, we're going to be required to complete anti-bias training that has specific topics that the division is going to demand that we be exposed to. But these are some thinkings for, these are some ways for us to think about our very next evaluation to check ourselves such that when it comes time to provide the opinions and conclusions in our report, those opinions and conclusions can be more accurate. They may not be instantaneously exactly accurate, as if you had a crystal ball exactly free from bias, but hopefully they can be more accurate and more representative of the actual qualification of the injured worker or the examinee for benefits. In other words, the whole purpose of these considerations is to provide benefits that are accurate. So does anyone have anything that they'd like to share on that, or a question that they'd like to ask?
Yes, this is Dr. Monahan. I'm gonna see if I put my face on there. If it looks ugly, I'm putting it off. Do I see the video? I want to thank you because this is a timely topic. Do you see me?
Yes, I can.
Is it bad? Don't answer that.
I'm saying you, no, you look great.
My hair. Okay, I want to thank you. I have a lot to say about this subject, but I can't do it now, but I do have some concrete questions to ask. Within our reports, do we not mention the race, religion, sex, or age? Those are just a few items.
Only if it's relevant to the condition.
It's not relevant. Normally, I was taught just, 32 years old, blah, 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 Catholic, blah, blah, whatever. Don't even mention that now, right?
Well, some of the physical things you can mention just as identifying data, such as a 32-year-old Caucasian male. I can't see how any religious affiliation is relevant. Can't see how any sexual orientation is relevant. So some of the physical characteristics may be relevant later on in your exam. So I would say limit it to only that which cannot be misconstrued as irrelevant. How about that?
Okay. So again, I have a lot to say, but I'll just leave it at that right now. This is a hot topic.
Okay, so Dr. Monahan, so you're a psychologist, and of course you're have a lot more experience with bias than I do, but I've shared with you, my research on the topic. So what can you add to it in terms of any suggestion for us in terms of being more neutral evaluators?
Well, I actually check myself when I get I'm gonna say check myself at the door, when I get a patient, an applicant I have to examine, I actually go over all of that with myself. This is just something I do with anybody I work with, any clients or applicants I work with. I check to make sure when I enter a session or when I enter a QME evaluation, I'm not being biased, because you might have those things, but I actually check myself to make sure I'm not going in there against the race or anything. And there is a lot of bias. A lot of people come to me, maybe because I'm a woman. Half of them don't know I'm Black because of my last name. But when they tell their stories, I feel that some of them have been discriminated against. And I don't think you would know it unless you know it. You know, it's kind of hard to put your finger on it, but unless you've been through some of that, you may not know it.
Right, right.
And then so when people sign these declarations, I'm not biased, that's a bunch of crap. I would sign it if I was biased, right?
So,
yeah.
in your opinion, is it accurate that your opinion is that it may be possible for us to check and reduce some of our biases, but not completely eliminate them because of the creatures we are?
Yeah, I think you need to, and I think this is what they're trying to do, the workers' comp is trying to do, is for us to look at ourselves before, but it's just something I automatically do. Because I have all kind of patients and all kind of people, and I can't have as many patients or QME evaluations if I'm just straight up only for women, or only for Blacks, or only for this. I check to make sure I'm not bringing that into the room.
Good. And that's the purpose of the disclosure requirements too, as well, because all of that language is contained in the disclosure requirements, but 9 out of 10 QMEs are either unaware of the disclosure requirements, the word is requirement, or they just have omitted it from the procedure. But those disclosure requirements contain that very language.
I wasn't aware of those requirements. It's just something I just do. So I have to admit that I don't remember signing those disclosures.
It's not something that you sign, but it's something that you're required to go over with the examinee before beginning the face-to-face. I usually hand them a piece of paper that has the code. It's California Code of Regulation 40. It's a written code. So you can copy and paste that from your Google browser, put it on a document, a Word document, and hand it to them and have them read it. And then when they're done reading it, of course, they won't understand it because it has some large words and some laws in it. They won't understand it. And so then you go over it with them interactively and confirm that you get a head nod from them on each issue. And really the bottom line of the disclosure requirements is, Mrs. Jones, you look them straight in the eye, Mrs. Jones. So what this means here is that if at any time you're not comfortable here during the evaluation, if you feel like the doctor's weird, doctor's rude, doctor's got some kind of attitude, you don't have to put up with that. And see, this causes you to check yourself. So that you don't be rude, so that you don't have an attitude, so that you don't have any of those things that are right there.
I've never done that.
It's kind of like
tomorrow. Have a QME tomorrow. I'm going to do it. I've never done that.
And see, when you do that with them, when you let them know that they can leave at any time, in other words, that they hold the cards here, that they're in charge, when you let them know that, and then you behave properly, it cements the relationship and it creates a rapport with you such that you can carry on with the evaluation knowing that you both trust each other and you're both going to be honest. And it helps to get to accuracy in the evaluation. Okay, so we have one question here and then we'll conclude. One doctor says, if you've consistently, emphasis on the word consistently. Does everybody see the chat?
Yes.
This is in the chat. It says, if you've consistently been denied payment by a specific insurer, consistently had to hire an attorney to obtain payment, along with P's and I's, can you refuse to accept cases from that carrier or somehow try to control your bias against the defense as a result of their historic treatment of you? Well, that's hard to do. I admit it. It's hard to do, but that's what we're supposed to do. So I don't know what I can offer to help you in that regard, but except to say with each case, you have to turn the page and at least give the examinee, an honest look each and every case. And then finally, does everybody have access to the handouts? Everybody has their link?
I do.
Yes.
Okay. Okay, we're going to conclude today's discussion. I'll let you know that we have many great topics coming up over the next several weeks. We're going to have some topics that will not qualify for continuing ed credits because they talk about the business side of the QME. So on November 10, we're going to have talk about QME profit and how you can maximize your profit. And then in January 2022, we're going to start with, again, more non-continuing ed credit topics about how to succeed as a qualified medical evaluator. So make sure to join up every Wednesday. And I look forward to seeing you. And I thank you for joining me today.
Thank you.
Thank you.
Mhm.